Hello everyone, Dr. Vaishali here. Welcome to Law, Simple, Pure and to the Core. Today we are going to discuss Doctrine of Rule of Law. In our legal curriculum, some subjects are actually subjects of international importance or subjects which are internationally applicable. For example, jurisprudence, interpretation of statutes or criminology for that matter. Similarly, there are certain doctrines which cross international boundaries and are accepted by almost all the civilized nations. Rule of law is one of such doctrines which is respected by lots of civilized countries, either by legislative enactments or by the constitutional guarantee. So let us discuss what is the doctrine of rule of law. As provided or propounded by Professor Lon Fuller, rule of law means a good system of law which serve needs of people if it is to be obeyed. So good system of law basically must serve people and then only people will obey the system. Rule of law provides fundamental principle of good governance which guarantee enjoyments of rights and liberties. As propounded by Professor Ross, rule of law can be found even without legal system pursuing moral good. So existence of legal system is not requisite for application of doctrine of rule of law. It can be found in moral societies pursuing moral good. Let us briefly discuss the idea of rule of law. As I already told you in my previous lectures, in law, things speak for themselves. Res ipsa loquitur, which means law will rule. Rule of law literally means law will rule and no one else will rule. Doctrine of rule of law comprises a set of formal and procedural principles or some substantive and procedural rules which needs to be followed. Doctrine of rule of law or the word rule of law is derived from French word le principe de légalité. It means principles of legality, principle of what is legal and what is illegal. Rule of law assures rights and liberties to the citizens. The concept was formally coined as rule of law by Justice Coke, but even before that, it was embedded or it was there in the philosophies of lots of Greek and Roman philosophers. So rule of law has a very long normative history. Let us go through the definition of rule of law. According to Black's Law Dictionary, rule of law means legal principles of day-to-day application, approved by the governing bodies or authorities and expressed in the form of logical proposition. According to Oxford Advanced Learners Dictionary, rule of law means the situation in which all the citizens as well as the state are ruled by the law. Now let us talk about rule of law in general. Rule of law briefly means that people in position of authority should exercise their power within a constraining framework of well-established norms, let it be legal or moral, rather than in an arbitrary, ad hoc or purely discretionary manner based on their own preferences or ideology. It means power corrupts and absolute power corrupts absolutely, and rule of law is a check on that absolute use of power. So rulers and government officials, they are subject to the same law. It insists that the government should operate within a framework of law in everything it does, and that it should be accountable through law when unauthorized action by those in power is taken by them. So a common man commits a crime, punishment will be given to him. If a politician or an administrative officer commits a crime, same punishment will be given to him, and that's rule of law. As per the Stanford Encyclopedia, rule of law is not just about government. It requires that citizens should respect and comply with legal norms, even when they disagree with them. When their interests conflict with others, they should accept legal determinations or consequences of what their rights and duties are. Also, the law should be the same for everyone so that no one is above the law and everyone has same law's protection. So basically rule of law in general means everyone is subject to same law. Let it be a common man, let it be a politician, let it be a government official. Now, access to rule of law. The requirement of access is particularly important in two senses. First, law should be accessible. It should be a body of norms promulgated as public knowledge so that people can study it. So basically, people should know the law first, internalize it, understand it, figure out what is required from them, and use it as a framework for their plans and expectations and for settling their disputes with others. Secondly, legal institutions and their procedures should be available to ordinary people to uphold their rights, settle their disputes, and protect them against abuses of public and private power. All of this in turn requires the independence of the judiciary, the accountability of government officials, the transparency of public business, and the integrity of legal procedure. So access should be at two levels. First, access to law. It means people should know the law, they should understand the law, and secondly, they should have access to the court system. As coined by Indian jurist Upendra Bakshi, there are two notions of rule of law. Rule of law emerges variously as a thin notion, entailing procedural restraints on forms of sovereign power and governmental conduct, which may also authorize practices Holocaustian, which means destruction or slaughter on mass scale, of politics, and as a thick conception involving the theories about the good, right, and just. It means, as per Upendra Bakshi, it acts as a thin limit sometimes, or it serves as a thin notion when it curtails unauthorized use of power by politicians, and then it goes beyond that and thickens, and then it becomes better. It decides between good, right, and just, and provides for just. As per Joseph Ratz, the rule of law is just one of the virtues which a legal system may possess and by which it is to be judged. So, what is the parameter of legal system? Whether that legal system provides for the concept of rule of law or not, as per Professor Ratz. So, succinctly or briefly explained concept means no one is above the law, everyone is below the law, and certain connotations necessary for existence of rule of law are there, which are presumption of innocence. So till a guilt is proven, that person is assumed innocent. Double jeopardy means a person cannot be punished for same crime twice, and legal equality, which means everyone is equal in front of the law. Now let us briefly go through historical analysis of the concept. The rule of law has been an important ideal in political traditions of most of the civilized countries for millennia or for ages, and it is impossible to grasp and evaluate modern understandings of it without fathoming or understanding that historical heritage. Over here, few highlights needs to be mentioned. Concept of rule of law was coined as rule of law by Justice Coke, but it was embedded in expressions of Greek philosophers since 350 BC. Plato explained, where the law is subject to some other authority and has none of its own, the collapse of the state is not far off. But if law is the master of the government and the government is its slave, then the situation is full of promise and men enjoy all the blessings that the gods shower on a state. It means ruler should be a servant of law and not the other way round. As per Aristotle, law should govern and those who are in power should be servant of the laws. According to John Locke, rule of law brings predictability and certainty in the system. He wrote that freedom in society means being subject only to laws made by a legislature that apply to everyone, with a person being otherwise free from both governmental and private restrictions upon liberty. So according to John Locke, there are no restraints on personal liberty. But if his liberty and others' liberty conflict, then law intervenes. As per the Montesquieu's notion, work on the rule of law is best known in connection with his insistence on the separation of powers, particularly the separation of judicial power from executive and legislative authority. So, as per Montesquieu, rule of law is best protected in a society which guarantees for separation of powers and, precisely speaking, independence of judiciary. As per the most famous British jurist Dicey, the rule of law used to be a proud tradition that distinguished governors in England both from the executive domination of droit administrative in France and also from the fatuous and abstract certainties of paper constitutions in countries like Belgium, etc. For Dicey, the key of rule of law was legal equality. Dicey propounded the theory of law as a protest against the concept of droit administrative which existed in France. As per the concept of droit administrative, there will be two laws in the society. One law which is applicable to common man and the other law which is applicable to governmental officials. Droit means dual, so two types of law for two types of people is called droit administrative. Dicey opposed the concept of droit administrative and he provided for legal equality or every person is equal in front of law, whether he is a common man or a governmental official. So no man is above the law and every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. As per Professor Lon Fuller, he formulated principles of what he called the inner morality of law. Principles requiring that laws be general, public, prospective, coherent, clear, stable and practicable. So law should be general. So for everyone, they should be the same. Public, it means they should be known to public. They should be made public. They should be accessible. Prospective, it means they should be applicable from the date of lawmaking and not from the date at the time when law was not applicable. So it should have future type of application, which means prospective. Coherent, they should be coherent. They should be clear, easy to understand. Law should be stable. They should not change every now and then, and they should be practicable or reasonable. And he argued that these were indispensable to lawmaking. Reviewing Fuller's book, H.L.A. Hart asked in what sense these principles could be called a morality. They seem to be more like instrumental principles for effective legislation. So Lon Fuller, though he belonged to the Department of Philosophy technically, his principles are like guiding principles for effective legislation as per Professor H.L.A. Hart. As per Professor Joseph Ratz, the leading legal positivist, he claims that the rule of law is a precondition of individual liberty. He recognized the need for the government of men as well as laws, and that the pursuit of social goals may require the enactment of particular as well as general law. So he recognized the need for general as well as particular law. It means he agreed upon the necessity of special laws in special situations. He provided 9 points which are included in the concept of rule of law provided by Joseph Ratz. Number 1, law should be prospective rather than retroactive, they should be applicable from the future date and not from the past date. Law should also be open and clear to enable people to understand them and guide their actions in line with them. So law should be clear and enable people to understand. So people should understand the laws, and law should be that clear, or they should be written in that with that clarity. Laws should be stable and should not be changed too frequently, as this might lead to confusion as to what was actually covered by the law. So law should be changing as per the society, but it should not be changing every now and then. It should have certain element of stability which is necessary. There should be clear rules and procedures for making laws. The independence of the judiciary has to be guaranteed to ensure that they are free to decide cases in line with the law and not in response to any external pressure. So judiciary must be independent. There should not be any executive interference in the judicial work. The principle of natural justice should be observed, requiring an open and fair hearing to be given to all parties to proceedings. So, all the parties in the proceedings must be heard. They should get an opportunity to represent their case, and then only decision will be made. The courts should have the power to review the way in which the other principles are implemented to ensure that they are being operated as demanded by the rule of law. So courts, they have a power to review the way in which the other principles are implemented. So judicial review is there in Joseph Rath's concept of rule of law. Next, the courts should be easily accessible as they remain at the heart of the idea of making discretion subject to legal control. So people should have access to the legal system. And then the last point, the discretion of the crime preventing agencies should not be allowed to interfere with the law. So, in order to conclude, theory of rule of law, theory of rule of law is the work of philosophers like Plato, Aristotle, Locke, Dicey, Fuller, and Joseph Ratz, and it's still developing and enriching. So, concept of rule of law existed even before it was coined as rule of law by Justice Edward Coke. It was there in the philosophies of Greek philosophers, Roman philosophers like Aristotle, Plato. Afterwards, it was coined as a concept of rule of law and respected by lots of legal system. The concept is still developing and it is enriching day by day. Rule of law brings certainty, stability, transparency in the legal system. Being ruled through law means that power is less arbitrary, more predictable, more impersonal, less preemptory, less coercive even. It establishes what Fuller described as a bond of reciprocity, a mutuality of constraint between the ruler and the ruled, and in that sense, it mitigates the asymmetry that political power otherwise involves. So, rule of law brings just society. So, in the domain of rule of law, if there is a question on the concept of rule of law and you are a student and you have to answer the question, you have to start with the concept in general, necessity of the concept of rule of law as I explained, to avoid arbitrary use of power by the ruler. Then afterwards you have to go into brief historical account of the concept of rule of law, how it was there earlier, then how it was modified by the lots of philosophers and how it is still enriching by judicial decisions. Afterwards, you have to go through philosophies of different jurists like Aristotle, Plato, John Locke, John Fuller, Professor Raz, Dicey. You have to make a special reference to Professor Dicey because concept of Dicey or Diceian rule of law is accepted by lots of common law countries including US and India, as those were the colonies of Britishers. So Diceian concept of rule of law means supremacy of law. It means in the country no one will be supreme but law will be supreme. Then second connotation of Diceian concept is equality before the law. So every man is equal in front of law and he's subject to the same law. And then third connotation of Dicey principle of law is predominance of legal spirit. So what is spirit? Which is always alive. So as per Dicey, British man will never be ruled by a dead document called a constitution. Britishers are democratic people. They have a right to choose their representatives. They choose their representatives wisely. Representatives make law for the people. So they don't need a dead code like a constitution because legal spirit in Britain is alive as per Dicey connotation. And again, this principle is accepted by lots of common law countries. So you can go through the Dicey concept and you can provide a brief analysis of the concept, and then 9-point program provided by Professor Raz, which brings stability in the system. So this was my first lecture on rule of law. In my next lecture, I'm going to explain Dicey concept of rule of law in detail with some examples from some concrete jurisprudence on the concept. So stay tuned. Thanks a lot and goodbye.